Hello, I'm Sid Mendelson, Director of the Division of Investment Management. On my right is Tony Vertuno, Special Counsel to the Division. On his immediate right is Joel Goldberg, Associate Director of the Division. On his immediate right is Jerry DeMichaelis, Branch Chief of the Division. And on his immediate right is Burl Ellis, Assistant Director of the Division. The first speaker today will be Joel Goldberg.
Thank you, Sid. I'd like to start off our discussion of the investment company registration process by discussing when a company becomes a registered investment company. Generally, the first document that an investment company files is the Form N8A. That's the notification of the registration. That makes the company a registered investment company. It's not the registration statement. That's filed on the Form N1, which must be filed within 90 days after the N8A is filed. But as soon as the N8A is filed, you've got a registered investment company which is fully subject to the Investment Company Act. And even if the registration statement is not filed for some reason within the prescribed 90 days, even if it's not filed ever, the company remains a registered investment company until the Commission issues an order under Section 8F of the Act declaring that it is not a registered company. So a company that's filed in N8A must file the various reports and comply with all the other provisions of the Act. A company organized in the United States is the only type that can register automatically by filing an N8A. Foreign companies under Section 7D of the Act have to receive an order of the Commission allowing them to operate and register as an investment company. Under Rule 7D1, a Canadian company can in effect receive an order automatically if it follows the standards set forth in that rule. Those standards involve consent to the jurisdiction of the Commission, consent to the jurisdiction of courts of the United States, and other matters. The rule that the N1 registration must be filed within 90 days after the end within 90 days after the Form N8A is filed has one exception. If the company's fiscal year ends within 3 months after the filing of the N8A, then the registration can be filed within 3 months after the end of that fiscal year. For example, if a company is on a calendar year and it files in December 1st, it would have until 3 months after the end of that year, that is until March 31st, in which to file the registration. If the registration is not filed within the prescribed 90 days, the Commission can move to deregister the company under either Section 8F of the Act or Section 8E. But I would remind you again, until the Commission does that, the company remains a registered investment company.
I'd like to add one thing, and that is this, that while the statute in its substantive sections of the Act refers to a registered investment company, The Commission has taken the position in litigation that a registered company means a company that is either registered or should be registered. It cannot, a company, we have taken the position that a company that refuses to register cannot do with impunity those things that are prohibited from a that those things for which a registered company is prohibited from doing. Otherwise, the equity position would be topsy-turvy.
You mean, Sid, that even if the company didn't file its N8A, if it should have filed an N8A, it'll be treated as a registered investment company for that purpose.
For example, in the Fifth Avenue case, we charge Section 17, which if one looks at Section 17, he'll notice it refers to a registered company. But we charge the Section 17 because the affiliated persons there who we charged, by refusing to register Fifth Avenue as an investment company, would have the peculiar application of being immune from the act, and it's an asinine result. So apparently the court agreed with us. We've done this at least 4 times, and we have never been turned down.
Now, the Form N8A, as we said, registers you under the Investment Company Act, but investment companies have to register under 2 statutes, the Investment Company Act and the 1933 Act. Both of those registration statements under those 2 acts are now filed on the Form N1, and Tony, I think, will talk about the 33 Act registration process.
Well, Joel, you mentioned the fact that they have to register under 2 acts. This would be 99 times out of 100. That would be true. But if you had a company an inadvertent investment company that didn't wish to sell its shares, it would only have to file under the 40 Act. It's only but in 99 chances out of 100, the company wishes to sell shares. So you're right.
I might just expand on that slightly. The tests for registration are not quite the same under the 33 Act. Of course, the test is whether you're making a public offering, and under the 40 Act, the test is, among others, whether you have 100 shareholders and other things, which were discussed during yesterday's session. So, as Sid points out, it is theoretically possible to be subject to the Investment Company Act, but to not be subject to the 1933 Act.
Thank you, Joel. As you pointed out, an investment company does have an obligation to file a registration statement under the 1940 Act, regardless of whether it's going to make a public offering of its shares, which requires registration of its shares under the Securities Act of 1933. And although the Form N8A, the notification of registration, is sufficient to create the status of registered investment company for the company which files it, it has not completed all the requirements of registration by filing that document, although it has become registered. The Act in Section 8B requires more complete information to be filed as part of a registration statement, and the Commission has promulgated forms for registration under the Investment Company Act of 1940, which do give a great deal more information about the company than would be found in Form N8A. One of the principal things to be covered in that document would be, of course, the investment policies, the identity of the officers and directors, controlling persons, owners of stock, and so on, many other things. And it's quite a detailed registration statement. Now, we're not going to get into, I'm not going to get into the contents of that statement because Jerry DeMichaelis will be covering that a little bit later. But I just wanted to bring that up to point out, as Sid and Joel have discussed briefly, that once a registered investment company has filed its notification, it still has a responsibility and a direct responsibility under the Investment Company Act to file a complete registration statement on the appropriate form, which takes care of that requirement under the Investment Company Act of 1940, which is, in fact, a requirement separate from any requirement imposed by the Securities Act of 1933. However, Section 24 of the Investment Company Act is concerned with the connection between the 1940 Act and the Securities Act of 1933. For instance, it provides in Section 24A that the registration statement filed pursuant to the Investment Company Act may be filed by the company or may be submitted by the company as partial fulfillment of its requirement to file the registration statement required by the Securities Act of 1933. And in fact, the forms which we have, the 33 Act forms which we have adopted, formerly the S5, now the N1 and N2 for the management investment companies, and the other forms as well, lean quite heavily, in fact almost completely, on the 1940 Act registration statement. In other words, an investment company has a first obligation to file its 1940 Act registration statement. If it wants to make a public offering of its securities, it has to register those securities and file a registration statement which satisfies the requirements of the 1933 Act. But the 1933 Act registration forms for investment companies rely quite heavily, in fact are almost completely made up from items of the 1940 Act registration statement. So once they do the 1940 Act registration statement, the 1933 Act statement is merely a matter of selecting those items on the 40 Act registration statement which satisfy the 33 Act registration statement item requirements. So, and of course, in cases where an investment company decides that it wants to make an offering as soon as possible after it's registered, it commonly files both forms together, or in the case of our new forms, a single form for both purposes, and the documents can be reviewed as one with an eye to determining whether the requirements of registration under both acts are satisfied.
I'd like to emphasize one thing as the discussion continues here. As these gentlemen indicate what has to be filed, I want you to go back to Section 1B. If you can remember, if you have the statute, I'd suggest you look at it. If you don't, you might recall what I said yesterday. The 40 Act registration statement, unlike an ordinary 33 Act registration statement filed by a commercial company, is more or less a contract with the shareholders of the company. It will say what it will do. And in many instances, as I'm sure Tony and Jerry will amplify, changes can only be made by shareholder consent. So unlike a 33 Act of a commercial company, which registration statement must be true at the time of filing and while the sale is going on, thereafter, for good reason, things in the registration statement in the 33 Act can be changed if changed in good faith, and the promoters or the sellers had no reason to believe it was going to be changed at the time they sold it.
Sid, I might just, if I can, interrupt you very briefly. Although that's true, as we'll be getting to shortly when we talk about the recital of investment policies and freedom to change those policies, there is some limit to the amount of freedom you can reserve to respond to changed circumstances. I just want to point that out. That
Yes. Well, what I'm trying only here to emphasize the difference in an ordinary registration statement filed by a commercial company. There, the test, is it correct, is it true at the time of the filing and at the time of the sales? Thereafter, if circumstances change, there is generally speaking, there is no violation of the 33 Act. On the other hand, matters put in the 40 Act, generally speaking, with some exceptions, cannot be changed as readily as a 33 Act statement can be changed. And I think this is a point that you ought to look at in connection with 1B, because as you recall, for example, changing policies, we talked about the abuses of changing investment policies. We talked about the abuses of changing priorities of securities and things of that sort. Now, this is one of the places in the Act and in the registration process where 1B is nailed down in the practice of the Commission in accordance with the Act. So I just want you to watch it.
All right, thank you, Sid. To get back to our old friend, Section 24, we should also note that after the Section 24A establishes the relationship between the 1940 Act registration statement and the 1933 Act registration statement, Section 24B, which is somewhat important to note here, I think, requires that any sales literature or advertising material used by any investment company in connection with the offering of its shares, other than a closed-end investment company, must be filed with the Commission. As you may or may not be aware, the Commission formerly had a statement of policy relating to sales literature used by investment companies, which went into a fair amount of detail about the contents of the sales literature. Recently, the Commission has withdrawn that statement of policy and has proposed for comment a rule which would replace it, but which would be substantially shorter and deal much less with any of the details of the contents of sales literature. However, in connection with the Commission's withdrawal of the statement of policy and its proposal to adopt the new shorter interpretive rule, the Commission also announced that it expects sales literature to be reviewed more completely as a part of our inspection procedures. In this connection, although it has not been done yet, the division will be trying to develop some guidelines or procedures for our inspection people to use when making inspections and looking at the sales literature in that connection.
Tony, before you get too far away from 24A, I'd like to point out that, although you may have inferred the same, that under the 33 Act, it is the securities that are registered. And, of course, under the 40 Act, the company is registered. And 24A provides for the registration of securities under the 33 Act. And it says that the company can file the following, which is the registration under the 40 Act, in lieu of what it would be required to file in Schedule A of the 33 Act. Have you ever known of a case where a company chose to file the registration statement that would pertain to to Schedule A rather than the requirements of the 40 Act? What would we do if they did that? It says they may file. It doesn't say that they have to. Have you ever known of such a case, Sidney?
No, I haven't. No, I haven't known any such case, but I think probably the situation is moot now with the filing of one form, that to cover both the 33 Act and the 40 Act. I think that probably that question will no longer even be viable.
Well, also in that connection, Section 24A also provides that when that is done, they can file that statement. As I mentioned before, it can be filed as part of their registration statement, but the provision which allows them to file the 40 Act registration statement in lieu of Schedule A information also says they should file that and such other information as the Commission shall prescribe. And of course, the Commission has prescribed the 33 Act form for companies, 40 Act companies registering securities under the 1933 Act. And as I pointed out, we probably wouldn't mind, since the 33 Act registration statement is only part of the 40 Act registration statement. The 40 Act registration statement is much more complete. So if somebody actually wanted to file a 30 Act registration statement and have a prospectus with the entire 40 Act information in it, they would probably include everything that's already in our item requirements for the 33 Act statements, but they would be filing really more than they would have to. So I think just about everyone would rather elect to file to follow our 33 Act form and our prospectus requirements, because they are somewhat smaller in scope than the entire full-blown 40 Act registration statement. Does that get to the point you raised, Burl? Thank you. Okay. Now, the other important area in Section 24, I guess there are really two, but they both relate to the same thing, and that's the use of post-effective amendments and the registration of additional shares. And those are Sections 24E and Section 24F. Section 24E permits investment companies to register additional shares pursuant to post-effective amendment. Now, this is peculiar to investment companies because under the 1933 Act and the rules thereunder, industrial companies or companies other than investment companies are not permitted to do that. They're required to file a new registration statement every time they want to register additional shares.
Tony, do you think one reason for that distinction might be that in the case of a regular industrial company, the number of shares being issued is a material fact in a very real sense? How much capital will this company be raising? How many shares will be outstanding? In the case of an open-end company, it's perhaps a bit more of a technical question. How many shares will be registered?
Joe, I think that you're right in this way. There's no, because of other sections of the Act, the issuance of shares, which must be issued at asset value, net asset value. There is no dilution of shares by additional shares. I also think that the Congress recognized the way of doing business, that a mutual fund has to have a continuous offering or it will dissolve. So that to say it's only going to issue so many shares is almost misleading in itself, because it's going to continue to issue as many shares as it can sell, simply to prevent a net redemption position from taking place. If you have, as we discussed yesterday, a mutual fund is an open-end company which offers shares that can be redeemed at the option of the shareholder. Therefore, if you don't continue to sell, you'll have a shrinkage, and it's immediate, and the immediate effect of a shrinkage is the inability of the manager to manage the assets of this fund. Many tell you that they can't properly manage a fund in a net redemption position. So I think it was both situations. One, the Act recognized first the continuous offering. Two, it then took steps to make sure that that continuous offering would not result in any type of a dilution by saying the shares must be sold for net assets. That you do, in other words, if the net asset is 10, you can't, except under most extraordinary circumstances, you can't sell them at 9 or 8. You got to sell them at 10, so that the new shareholders will not be diluting the old shareholders.
On the other hand, Joe, we've taken the position.
There's a question here.
Can you resell the redeemed shares, or do you have to re-register them to sell them?
If you would leave that question, we're going to cover that in the next.
The question
next few minutes.
The question was, can you resell the redeemed shares? You have to, and we'll take that up, as Tony said, later. You have to redeem it.
The point I was going to bring out is that we have taken the position with a closed-end company, not an open-end company. Sid was talking about that the number of shares being offered was material, where there was a substantial reduction between the time the red herring had been filed and the time the company went effective. The companies usually do not like to recirculate as they would have to when they are reducing the number of shares being offered at the last minute. But where a closed-end company is going to engage in a certain line of business that would require a certain amount of capital, and then at the end they are reducing that amount substantially, we've taken the position that it was material and they should recirculate the prospectus.
Burl, was your position based on the theory that even in the case of a closed-end investment company, which only intends to invest in other shares and which can do that with a smaller size, that the smaller size might reduce the possibilities of the company to be properly diversified or to make certain other changes?
Yes.
Well, I'm kind of glad you mentioned that, Burl, because it gives me a chance to say something I didn't say at the outset, that the provision in 24E, which permits investment companies to add additional shares to its registration statement by post-effective amendment, is not available to closed-end companies. It's only available to open-end companies, unit trusts which offer redeemable securities, and face amount certificate companies. And I guess this all ties in with Joel's question about why is this different from industrial companies or from closed-end companies. I guess one of the reasons, and there may be many which I'd rather not try and explore right here, but certainly one of the reasons is probably the fact that in offerings by industrial companies as well as closed-end companies, the size of the offering is a significant factor in itself. And that's probably one of the reasons. But rather than get off too long on that subject, I'd like to get back to what 24E, 24F are doing for the investment companies who can use it or use them. When investment companies are permitted to add shares to its offering through the use of a post-effective amendment, they're also put under the obligation by 24E to update the registration statements by the use of an amendment, and the declaring effective of the amendment then starts their Section 1133 Act liability running again. This, of course, could be another problem in that if additional shares are added to the offering without any act which restarts the Section 11 liability, you would have the anomaly of having a prospectus in use which may or may not carry prospectus liability with it for the issuer and the underwriters who are using the prospectus. Well,
Tony,
yes.
Can I say that the division has been faced in this area with a problem that the Division of Corporation Finance has not been faced with, and that is, as you know, under Section 8 post-effective amendments have to be declared effective if the Commission finds that they are not materially misleading on their face, and it's in the public interest to do so. With respect to post-effective amendments of general commercial companies, the Commission's delaying in a post-effective amendment, delaying the effectiveness of a post-effective amendment, doesn't materially affect the company's business. But when the Commission delays, or the Division delays, the effectiveness of a post-effective amendment in a mutual fund, the effect is that redemptions continue and sales stop. And the result is that you have a shrinking fund, as I mentioned before. So we have a particular problem in this area, and that's why we are very reluctant at times to accede to the wishes of the Division of Enforcement when there's an investigation going on in which they say, well, no comments, don't make it effective. We are, in this particular case, where there is conceivably can be a material harm to the company by not declaring the registration statement effective, where that same, because it's really not declaring the registration statement effective, because the post-effective amendment in many instances is just the adding of additional shares.
Sid, couldn't a company whose post-effective amendment we refuse to make effective simply file an entire new registration statement?
Yes, they could, at which point they would have to wait a minimum of 20 days unless we accelerate it.
But then after that 20 days, unless we stop order them, they could then sell shares.
That is correct. They have an alternative to do that, but it will always cost them a minimum of 20 days to do. Now, as you know, we had one company that continued to do that. It would never file a post-effective amendment. It would always file a new registration statement in order to disregard any comments of the staff. I might add that that company and its managers are presently in a proceeding to determine whether or not that company and its management should continue in existence. I'm referring to First Multifund and its managers.
Sid, I might just add one final point on clearing post-effectives. If there is a private investigation taking place of a company and therefore enforcement has asked us to not clear the post-effective, we have to interpret the public interest standard of Section 8C in terms of two conflicting public interests. One, of course, is the public interest in not allowing shares to be sold of a company which might be in violation of the law, but the conflicting public interest is in causing sales to be stopped, where shareholders might be harmed by that in the absence of any finding by the Commission or anyone else that the company has been in a violation, and it's an extremely tricky thing.
I think you state the question precisely. I think that it's the dilemma that we are put into when the division is asked to make that decision. And in many instances, we go right to the Commission with our recommendation one way or the other. On one hand, we wish to cooperate with the Division of Enforcement, and generally we do. On the other hand, there is a public interest to protect the innocent shareholders who are already there and who are and can watch their company literally go down the drain by a delay in sales. So this is the dilemma that that we face, and we hope we make the right decision each time. But it is a dilemma, and as a matter of fact, the division is now has a task force looking at this problem with the hope of coming up with some rule that would conceivably would solve this dilemma for us.
Thanks, Ed. I'd like now to get back to the question which was asked from the floor, which is when shares are redeemed or repurchased by an open-end investment company, must they be registered again pursuant to the 1933 Act before they can be again sold to the public? And the answer to that is that the Commission has taken for many years the position that they must be registered again because it involves a sale by an issuer, which is, for which there is not any other exemption available under the 33 Act, must be the subject of registration under the 33 Act. In other words, the issuer, once he requires the shares and wants to resell them, has to comply completely with the 1933 Act in regard to those shares, including a registration. Now this... Yes.
Go ahead. Well, I was going to say that this is not only a long-standing interpretation of the Commission with respect to investment company shares, but it is also stemmed from the interpretation of the Commission that with respect to a corporation repurchasing its shares, a commercial company, and putting them into Treasury stock. The Commission for a long time has taken the position that Treasury shares sold to the public must be subject to a registration statement.
Yeah, thank you, Sid. Anyway, this really gives rise to two problems faced by open-end investment companies and to some extent by unit investment trusts, but mostly by the open-end management companies. And that is, one, making sure that the amount of shares they have registered is sufficient to cover the shares they are selling, and two, the problem of paying the fee on the shares that they're selling. This latter problem can be quite burdensome in an investment company that has a high turnover of shares. A lot of investors buying and redeeming during the year can cause quite a high volume of shares being sold, and therefore quite a high fee required to be paid, even though the overall size of the fund doesn't seem to bear much relationship to the amount of fees they have to pay every year. Well, in the past, we've had a number of problems in regard to the number of shares registered. Although it might seem like an easy matter to keep track of how many shares you're selling and how many you've got registered, and to come in with an amendment pursuant to Section 24E to register new shares, which incidentally is only a one-page amendment, not counting the signature page. It would seem like the easiest thing in the world for companies to do. Nevertheless, this was one of our constant problems. We'd get a call from a company and say, or counsel, and be told, guess what, we just discovered that we sold out our last registered share 2 months ago, and we have been selling shares without having a registration statement for the last 2 months. Well, because the problem was widespread enough, Congress gave us authority in Section 24F to adopt a rule which would permit companies who found themselves in that situation, if it existed for no more than 6 months, to file, in effect, a notice which had the effect of retroactively registering the shares that were sold in excess of the previously registered number of shares.
Tony, did that problem become especially acute when the money market funds became popular and you had thousands and thousands of shares being redeemed and sold in short periods?
No, because the rule was adopted before the money market funds became popular.
Right.
Well, I'll tell you why it was adopted, Joe. We were faced with very tough decisions. A company would sell, conceivably, a company would go merrily on and sell its shares, and they had almost an incompetent person keeping track. We used to call it a little old lady in tennis shoes, and literally, when we went in on inspections, they had some person that was ready for retirement, or even ready, past ready, keeping track of these shares that were sold, and she didn't have a calculator, and the result was that. Time and again, she miscalculated, and a company would sell $2 or $3 million worth of shares in a boom time, all without registration. At the same time, they were sending out a prospectus that gave full disclosure. So you had a technical violation, if you will, with no substantive violation, because the investor who had purchased these shares purchased them with a perfectly good prospectus. And the result was, as long as the securities were going up, nobody cared. But the moment the securities would go down, Section 5 liability took place for 1 year, at which point these people who had bought with full protection of the law, because they had the disclosure, but they had a put for a year to the company. And if the market went down, the company had a contingent liability for 1 year from the date of the sale. And it came down to a question of unjust enrichment, where these people, relying on a technical violation, these shareholders who had bought simply because the shares had not been registered, not that they didn't get full disclosure. So the staff really had time and time again had to face this, and there were offers of rescission. There was no problem of an offer of rescission when the stock had gone up, because nobody'd take it. They'd redeem at the present net asset. But if the stock went down, then they could get their purchase price plus their load. The purchase price including their load. It became a real liability, and so that many times we had the investment advisor, if it had any money, indemnifying the fund for any losses in order to continue on. We've had several instances in which the fund had a liability that conceivably would bankrupt the fund if the put was exercised. So we, together with the investment company industry, supported in 1970 the amendment to Section 24, which allowed what Tony is going to get into, which allowed the company to get some relief. But I want you to keep in mind that the relief here is with respect to a company who is not violating Section 17 of the 33 Act. There's no fraud. It's a completely good registration statement. A completely good prospectus. And all we're doing is cutting off the possibility of people becoming unjustly enriched.
Cindy, do you know why we decided to do it only for 6 months retroactively?
Yeah. You had to cut it off someplace. It seems to me it seems to me that if a company books and records were some screwed up, that it didn't discover that it was selling for 6 months, we just felt that is as far as equitable relief would go. At that point, internal controls being so bad that we just felt that the relief was not appropriate after 6 months. Now, we could have said 7 months, we could have said 10 months, could have said 3. We arbitrarily agreed to the arbitrary figure of 6 months as a reasonable time in which some auditors should catch the mistake that was being made.
Okay, thanks, Sid. Now, you might suppose that with the adoption of Rule 24F1, this meant an end to those kind of problems. Well, wrong. We still have them, but fortunately they're much less frequent. But it still happens that we'll get a call from somebody who says, well, we have a problem, we have oversold and we've sold a bunch of unregistered shares. We say, well, no problem, just file 24F1. And they say, yes, but that only takes care of the last 6 months, and for the 3 months before that, we still have so many shares at so many dollars and so on. It still crops up once in a while, but it is much less frequent and doesn't take near the amount of staff time that it did in the past. Incidentally, in case I didn't mention it before we started the wider discussion on this rule, to take advantage of 24F1, the company files a notification giving the number of shares sold during the preceding period, which were not registered, and is required to pay a fee on those shares equal to 3 times the amount of the fee which would have been required had it been paid when it was supposed to have been paid. So there is a penalty feature involved in the fee payment area.
Tony,
Yes.
in the case you posed, where they've been selling for 9 months without registration, what would they do about those shares that had been sold the 3 months before they could use the 6-month rule under 24F?
Well, we would do the same kind of thing that a company would have done before, where they didn't have 24F and there had been an oversale. We'd have to look at each case and decide what we thought had to be done, and then the registrant would have to decide what it was going to do. The most common remedy, if you will, that happened in the past was we sought disclosure of the fact and the possibility that there might be a contingent liability for the fund, and also we encouraged indemnification of the fund by the advisor. In other words, if anyone did effectively make a rescission which would cost the fund money, the advisor would make that good to the fund.
Well, then you would say that in our inspection process, to those people watching this tape that are in the inspection area, that this is still a problem, and that they ought to determine the amount of shares registered as against the amount of shares sold to determine whether there is a contingent liability. Isn't that true?
Yes.
Do we ever require registrants to notify shareholders who have a right of rescission?
The question is, do we ever require registrants to notify shareholders that they have a right of rescission? The answer is not so much that we require them. In some cases, we make it known that we think they ought to be notified. But to get, I guess, to the bottom line, we'd have to say that it's been the small minority of cases in which notices of an oversale were sent to those people who bought during an oversale. It's much more usual for the disclosure, if any, to be handled in the case of a prospectus disclosure advising presumably potential purchasers that there was an oversale, that there might be some effect on the fund, but that the fund and the advisor don't think there will be any effect. Now, sometimes the prospectus, which has this added disclosure in it, is recirculated to all the holders, but generally, or in most cases, a specific notice to all the people who had bought during the oversale is not made.
The only
Well-
time when we would do that is if the company decided to make an offer of rescission. Obviously, an offer of rescission has to be communicated to those people who, if it's in good faith, has to be communicated to those people who have the right of rescission. You can't make an offer of rescission and tuck it under the mattress.
Okay, I think in the time remaining on this tape, I'd like to finish up by discussing rules 24E2 and 24F2. And these two rules address the burden of fees paid by open-end companies who have turnover in the sense that they are redeeming or repurchasing their securities at the same time that they are selling new ones. And if they're paying registration fees on the new shares being sold and are not able to credit against those any fees that they've already paid on shares that are being repurchased, this could be quite a burden on the investment companies. Now, Joel, you asked about the money market funds, and this is where the problem became especially acute with the money market funds. The money market funds generally had a very high turnover in shares, that is purchases and sales, relative to the size of their funds in comparison with the other kinds of mutual funds. So the fee burden on them was especially acute. And while the investment company industry generally had asked for some relief on this before, once the money market funds got going, we felt quite a bit of pressure from the industry to try and do something to benefit them. Well, we ended up adopting two rules. We adopted Rule 24E2, which permitted a company, an open-end company or an investment trust, to credit the number of shares redeemed in the last fiscal year against the number that it was registering now in computing its fees.
In other words, you mean they would only have to pay a fee on the net new shares being sold?
That's correct.
Well, Tony, in doing that, were we taking the position that there was no need to re-register those shares?
Not at all, Burl. We were consistent with our view that the registration was required. We were saying that this would be a registration, and the same gross amount of shares would be registered, but the fee would only be paid on the amount of shares which is net in excess of the shares redeemed in the previous year. The other rule is 24F2, which was adopted pursuant to 24F, which gave the Commission specific authority to permit registration of indefinite number of shares. And in that case, the company can file a registration statement or an amendment to its registration statement and pay $500 and have the ability to sell shares on an indefinite basis. In other words, they would not have to keep account of the shares. They could wait until the end of the year, then look back, decide how many shares they had sold pursuant to the rule, see what the value of the shares was, and pay the fee at that time based on the number of shares actually sold and the revenues actually received for them. This rule also has a fee credit provision similar to 24E2 in that the shares redeemed can be netted out before the fee is computed. So during the same year, the shares sold pursuant to this rule, pursuant to the indefinite registration, and the shares redeemed or repurchased during the years are netted against each other, and the fee is due only on the shares sold net in excess of those redeemed or repurchased. Okay, are there any questions now? I think, yes, sir.
Is there a time limit as to when the company can take advantage of the shares redeemed to reduce the filing fee?
Yeah. Yes, the question is there a time limit on which the company can take advantage of the shares redeemed when using 24F2? The answer is yes, and there's also a time limit on Rule 24E2. On 24F2, the company has to file within 2 months of the end of the the fiscal year in order to take advantage of the fee credit provision. In 24E2, a company can file any time during the year, but can only credit shares redeemed or repurchased during the previous fiscal year. Once they get a year beyond that, then and they have failed to take advantage of the credit available from those shares, they have lost the chance.
Tony, is that restriction in there mainly as a matter of administrative convenience? That is, you reach a certain point, you just can't keep track of the shares that were sold a long time ago.
That's true in the case of 24E2. In the case of 24F2, it was also to provide an incentive for early filing. In other words, to have the funds after the end of the fiscal year quickly move to total up and its shares and keep track and straighten out its books and the amount of shares sold. I think we're out of time for this tape.
Are there any other questions? 2 minutes left. Go ahead.
Well, perhaps we can start, Jerry, on the investment policy recitals.
Well, rather than that, Joe, let me answer a question that Burrell had asked before, and that was with respect to that 6 month rule in the rule under 24E, and I've had a little time to think about it. If you didn't have a time limit of 6 months or some time limit, then the registration system would be totally in chaos, because somebody would not register stock for 10 years, conceivably, or 5 years, and then when somebody caught up with them, they'd file this notice and be able to get total relief by paying 3 times the fee. And obviously there would be really no incentive to count the shares or to do anything, because it wouldn't cost you anything, and you'd never know how many shares were in registration and how many shares were not in registration. So that the 6 month period was the period taken in order to preserve the registration process as such, because without a limit, the registration, there would be no incentive whatsoever to register.
I might point out in this regard that even if there is a slip-up on the registration of shares, and for a period of time the fund's prospectus is not accurately reflecting the number of shares outstanding, it would presumably, or the number of shares properly registered and outstanding, it would still accurately reflect the size of the fund, the asset value of the fund, which is, as a practical matter, more important to investors, I think, than the number of registered shares.
Well, that was the point. That the point was that there was no material harm being done to anybody by the unfortunate forgetfulness of the fund to register, because the people had the disclosure, and we assumed that they were selling at the proper net asset value, so that there was no real problem, no material problem. It was a technical violation, but as I said before, some limitation has to be put on it, because otherwise you'd have a chaotic situation of no one being compelled to register any additional shares.
We will be moving, and I don't think there'll be time to start it on this tape, but we will be moving shortly to the investment company policies under Section 8 of the Act.